Today, we're going to try to answer the question, what are the twin pillars of the UK Constitution? The term twin pillars, when considering the Constitution, was coined by the Victorian constitutional scholar A.V. Dicey and was first used in his 1885 book, An Introduction to the Study of the Law of the Constitution. This book considered, amongst other things, the key principles that make up Britain's uncodified constitution. Whilst Dicey recognised there are a number of important principles of the UK Constitution, including constitutional monarchy and the fusion of powers, he argued that there were two principles that upheld the UK Constitution and were fundamental to its very nature, hence his use of the phrase twin pillars. These twin pillars, he theorised, were parliamentary sovereignty and the rule of law. In the book, which is often considered a work of authority on the UK Constitution, Dicey writes, "The sovereignty of Parliament and the supremacy of the law of the land, the two principles which pervade the whole of the English Constitution, may appear to stand in opposition to each other, or at least to be counterbalancing sources. But this appearance is delusive. The sovereignty of Parliament, as contrasted with other forms of sovereign power, favours the supremacy of the law, whilst the predominance of rigid legality throughout our institutions evokes the exercise, and thus increases the authority, of parliamentary sovereignty." So, what do each of these principles mean? Parliamentary sovereignty is the notion that Parliament has the ultimate power in the political system. Dicey suggested that there are three key elements to the doctrine of parliamentary sovereignty. Number one, Parliament can make or unmake any law of its choosing. Number two, no other body or person can overrule Parliament. This means that Parliament can ignore the rulings of other bodies. For example, the Conservative-led Parliament under David Cameron refused to give in to the demand from the ECHR that prisoners should not be automatically barred from voting in UK elections. And number three, no Parliament can bind its successors. This means, for example, that any future Parliament could choose to reapply to join the European Union. The rule of law is the concept of a society that is regulated by an established system of laws. Any modern liberal democracy has to, by its very nature, exist under the rule of law. Dicey also theorised that the rule of law has three key elements. Number one, that the government is limited in its power by established law. For example, this is clearly seen through the process of judicial review in the UK. Recent prominent court cases, such as Miller v Brexit, which said Parliament must assent to triggering Article 50, and Miller v Prime Minister, which reversed Boris Johnson's prorogation of Parliament, are examples of this. Number two, everyone is equal under the law. Prominent figures in the UK are meant to be subject to the same laws as everyone else. For example, Tony Blair was interviewed 3 times by the police as a witness over the Cash for Honour scandal. More recently, Fiona Onasanya, the former Labour MP, was prosecuted and imprisoned for perverting the course of justice. And number three, the law must be administered by an independent judiciary court system. So, how strong are these principles today? As regards parliamentary sovereignty, arguably membership of international organisations, like the EU, has reduced parliamentary sovereignty. However, Britain's exit from the EU in January 2020 may have seen powers return to the UK Parliament. Additionally, although Parliament remains legally sovereign, new aspects of the UK Constitution, like the Human Rights Act and the process of devolution, mean it is no longer fully politically sovereign. As regards the rule of law, the independence of the judiciary has been questioned. However, in recent years, the establishment of the Supreme Court and of the Judicial Appointments Commission has arguably increased the independence of the judiciary. However, the notion of everyone being equal under the law has been increasingly questioned. The recent Dominic Cummings affair has shown that, at times, powerful figures are not, despite the public statements of the police and the government, treated equally under the law. Equally, the reduction in legal aid available for people who are forced to go to court has resulted in increasing inequality under the law. The ability to be successful in a legal case in the UK does largely depend on your wealth and circumstances, which surely means that people are not equal under the law. It is clear that despite still being fundamental to the UK Constitution, there are question marks over both parliamentary sovereignty and the rule of law in the UK today.